You're now live.
We are now live and in living color. They don't even say that anymore. Remember the peacock? It's in living color. NBC, was it? Okay. All right. It is Friday. And it's late. This is H88, an act relating to the certification of agricultural use for purpose of use value appraisal program. And Abby, you're with us. Commissioner Snyder is with us for this one or the next one. No, the next one is miscellaneous tax. Okay. So Abby, what's this one doing? And let me find. Now, what did I do? Okay, what happened to Abby?
I'm here, Madam Chair.
Okay, do you want to just walk us through this? Tell us what's going on.
Sure, so I can share, and I will pull up first the bill as it passed out of the House. It's very short, and I can explain that as soon as I get that pulled up.
Oh, that is a short one. There we go.
Okay, so can everyone see the as passed House version of H88?
Yeah.
So it really just has two sections. The effective date is July 1st this year. It allows the Commissioner of Taxes, it gives the Commissioner the discretion to waive the annual certification requirement for land enrolled in the agricultural current use program, as long as the Commissioner has satisfactory information demonstrating that the land and buildings continue to meet the other requirements to be enrolled in the program. And that is the extent of the as passed House version of H88.
Okay, what's the eligibility requirement that we're waiving?
So this waives the annual certification. So further up in this subsection F, you see that there's the requirement. The date has changed a few times in the past few years. The current requirement is that on or before November 1st, farmers enrolled in current use have to certify with the department that they're still using their land and buildings for agricultural purposes.
Okay, so this is a self-certification?
That's correct. So this allows the Commissioner to waive that self-certification as long as the Commissioner or the Director of PVNR is able to obtain other information showing that the land and the buildings are still being used for farming.
Okay.
So that was the extent of the as passed House. When the Senate Agriculture Committee took up the bill, they also had another current use bill, S61, that they changed slightly and added on to this bill. So that's what should be showing on your screen now. It's the Committee on Agriculture's proposed amendment. So this amendment keeps the that waiver authority that's given to the Commissioner of Taxes and adds a few new sections and changes the title to make it all conform. So this section 2 amends the definition of development. So when development is triggered, the land use change tax applies and land has to be taken out of the current use program. So this is amending the definition of development, and it's being split up a little bit. I've added subdivisions here for all of the different ways that development is defined, both what it is and is not. So I'm scrolling down, trying not to make anyone ill. What's being added is this new subdivision F that makes it clear that development, so being having land taken out of the program and applying the land use change tax, that will not occur when there's a solar generation facility that is in the aggregate in total on 0.1 of an acre of land or less, but the underlying land has to continue to qualify for the current use program. And it allows both agricultural land or open land if that open land qualifies under the forestry portion of current use. It allows any of those either of those two types of land to stay in the program. So if they have solar panels, that's on a very small parcel, it will not trigger development in the land use change tax.
Okay, so rather than put it on the roof of my house because it's doesn't get enough sun, if I put a couple solar panels on a 1/10 of an acre somewhere else on the property that's in current use, then that land is not disqualified from current use.
Correct. Then the land can stay in the program.
Okay, Senator Bray.
So I'm just wanting to check in and make sure I understand how that's measured. There have been discussions over the years of when you measure a solar, the footprint of a solar project, do you literally measure the amount of disturbed earth, like every post you drive? Or in essence, you're making a giant canopy. So the difference between, the size of all those panels compared to the size of the posts supporting them is very different. And there've been arguments going both directions. So I'm just wondering, what's the measuring process here that we're talking about?
That's actually, may I stop sharing my screen for a moment?
That never even occurred to me. Some people are saying it's just the area of the post hole.
Shadow versus footprint. Yeah.
Right,
Shadow
like-
versus footprint.
Right.
Footprint. Jill, do you know how these are?
Jill Remick, the tax department. No, I hadn't heard the disturbed earth piece. I think we were assuming it was the shadow essentially.
Yeah.
I mean,
So
I
if you
just
appraise them
wanted,
at night, there's no shadow. Yeah, and then that's your cover.
Well, the canopy, the earth under the panel,
okay,
that all the earth between the four posts.
so fine.
That-
I just wanted to, well, the canopy's bigger than the post. Anyway, so I just wanted to check to make sure we're being consistent, because I've heard some finagling about, because it comes up with a dramatically different way of, the footprint changes dramatically if you just start using the disturbed earth recipe.
Senator Pearson has joined us from GovOps, where he's been representing us.
Not yet. I'll be there at 2:45. I had a work.
All
had
right.
a-
Well, we're on the ag.
Oh, great little bill.
Yes, but the question has come up. When you're talking about the land under solar panels, are you talking just about the disturbed earth for the four posts? Or are you talking about the footprint of the entire panel?
One post.
Well,
One post, all right.
I'm not sure the answer to that. I believe, and I'm looking at Abby, this has got to be real small. This is not a solar field.
That's a
This
1/10
is-
of an acre.
So it's tiny, and it's just making clear that those don't impact current use, right? Isn't that so what land we're talking? Oh, you mean, could the posts be a 1/10 of an acre versus the whole array? Is that what you're basically asking?
Well, Senator Bray asked.
There's been a discussion over the years, for those who want to minimize how you're counted, they say, well, the only disturbed earth is my post. For those who are being sort of more, I don't know what, comprehensive, they say, no, it's the whole facility, just measure the size of that facility. And I think we have generally stuck with measuring sort of the shadow of the whole facility as what's involved. Maybe it's out to the fence line, I don't know what, but it's not this sort of fence post only thing. And I just wanted to check that we're still doing it the same way, that's all.
It's the location of a solar generation facility that is in the aggregate on 0.1 of an acre of land.
Yeah, so it's not disturbance. I think it's got to be the shadow then.
So, all right.
Well, I suppose if we're not distinguishing it from other bits of law, then it's just going to flow in with the way we're treating everything else, which is, as Ms. Remick said, like the footprint, the shadow. Right. So good to go. Thank you.
Okay. Other questions at this point? Senator Sorokin.
So I'm glad Chris is back. Is this applicable to farmland as well already?
Yes, it's applicable, Abby, correct me if I'm wrong, to any current use. That's what we're talking about is the
Well, this provision
no-
just is with forest land, I think.
no.
No, it applies to both types. Actually, that was part of why the language that was in S61 was changed. It initially only applied to parcels that were enrolled for agricultural use. It now applies to both that's used for agriculture and what's open land but qualifies as managed forest land.
Okay, that's why this section
Which
is.
is different.
And I wanted to go back to the first section. I actually have a history here on current use. I was on a summer study committee back, I think the first year I was a senator, and we were responsible for establishing the certification process because there were a lot of folks taking advantage of current use that were no longer farming the land. So we wanted this annual certification. So I was wondering, Abby or Chris, whether what's the reasoning? Is it that burdensome on someone to send in a postcard each year saying they're continuing to farm? And what is the check on that by waiving that requirement?
So I can start
Commissioner
answering.
Snyder to testify. So maybe we'll let him testify and that he might be able to answer that question. And then we have a full array of testimony.
I will add in my recollection is that there was, I don't want to say considerable, but definitely pushback from the executive branch in requiring this annual certification back then.
Senator McDonald, do you have a question at this point that?
I think the requirement to certify followed a short period of time when farms which had cattle and had manure pits stopped farming. They simply stopped farming, and no one notified current use that the farm was no longer an operating farm, and that caused problems. So we called for a certification, and that was put into law. I'd say 6-7 years ago, or I could be wrong. That's what caused the certification, which is a fairly recent phenomenon. And now there's a proposed change. Is that correct, Senator? Agriculture.
Okay, so let's let Commissioner Schneider testify, and then we will get to questions. Okay, Commissioner.
Thanks, Madam Chair. Good afternoon, all. Happy to be with you. For the record, Michael Snyder, Commissioner of Forest Parks and Recreation. Yeah, and so how can I be of help here? So I would just say, for the record, we support our piece of this is a very narrow piece. This is in the second piece that relates to the solar installation. And our piece is very surgical here, which we support this language, to be clear, to make it clear that solar installation on less than a tenth of an acre or less in open land within the managed forest land category of current use would not be seen as development. So that's the very surgical approach to make it possible for someone to erect a solar facility on a parcel enrolled in the forest land category, but we're keeping it out of the woods. This isn't anywhere in a forest land enrollment. This is only in what we call open land, which is non-forested land that doesn't qualify as agriculture. And we just happen to have that category on the forest land side that I guess the way I explained it when I was a county forester was that that's for recognizing that some people who own forest land might dabble a little bit in agriculture or gardening or agroforestry, but they don't qualify under the IRS definition or other definitions of farmer. And so they're ineligible for the ag program, but we let them have those acres in a mixed enrollment in forest land. We call that open land. It's not to be reforested. It's not eligible for agriculture, and it must not exceed 20% of the total enrollment. And so that's where we're limiting, we're limiting the erection of solar facilities in an enrolled parcel to that portion of a parcel enrolled in the managed forest land category. This language also speaks to something similar on ag lands, making it not development. But it's a little bit, but I'll leave the ag piece to the ag folks, I guess. So that's the part for us on the forest land category. And I'm happy to answer further questions on current use writ large, or by contrast, you're talking about certifications, that's on the ag side. On the forest land side, we have a whole nother approach to that, which is forest management plans, oversight by the county forester, and conformance reports, forest management activity reports. When you conduct some activities per your management plan, you have to report to the department and the Department of Taxes on that. So there's a whole reporting scheme and management planning scheme, and site conformance inspection scheme on the forest land side. The certifications is the approach taken on the ag side. It's very different.
Okay, Senator Pearson, what was the thinking on ag about? The one thing I can think is, what happens if a farmer's a little busy and forgets to send in their postcard? Do they automatically end up out of current use for the year?
Potentially, although I think there's a chance to cure, but maybe I'd look to Jill or Abby for that. I mean, that's not being changed here, is it?
Yeah. Let me find the,
Sort of is.
It's being changed in the House bill, Chris, not the bill, not your amendment, but the bill the House sent us.
But maybe it's been a few weeks, so let me.
Commissioner may waive the eligibility requirement. So
Oh,
Jill,
right.
what does
So-
this do?
Sure, thank you. Jill Remick, I'm the Director of Property Valuation Review at the Tax Department. So the purpose of the original H88, it actually came about as, there was a few different ways we could tackle this, but we are absolutely still going to send out the required ag certification to all the parcels that applies to. It's usually a little over 7,000 parcels every year that have to complete the ag cert. We actually pre-fill the form and mail it. And then we do send another reminder one to folks that we haven't heard from. This is really designed to get at the folks who there's usually, between 1 and 200 every year that do not submit it, but may still be qualified. And right now, the only way we have to mitigate that is to withdraw them, which kicks off the process of land use change tax valuation. Then they have to formally appeal. And then inevitably, if they're able to prove that they are still eligible, we then bring them back in. So it creates this several month process of sort of a stressful period of time. Whereas if we could just say, okay, you didn't get your ag cert in on time, but if you provide us with your updated maps or your updated lease, then we don't need to actually formally withdraw them, start the land use change tax process, and force them to appeal. And that's sort of the only avenue they have right now if they don't file an ag cert. So this is only for by the time we get to the actual point of the appeal, there's usually several dozen every year that are absolutely still qualified. And their only avenue to stay in is to go through this multi-month appeal process. So I want to be really clear, we're definitely not asking to just not do the ag cert. This is when we get to the end of that cycle and we still haven't gotten several from farmers who are still qualified. We want to be able to accept their proof and keep them in the program.
Okay, so you're going to keep sending out the postcards for them to sign. But you
Absolutely.
get a couple dozen folks every year who don't send them in, but who are still farming. And so this says if somebody from the tax department drives by and there's a manure spreader out in the field spreading, or there's corn growing, or cows, that he can say, yep, they're still farming, and have rather than have to go to court per se and appeal and go through an appeals process, this is kind of saying, yeah, we went out, they're still farming, and not have to throw them out and then put them back in and do land change tax and, okay.
Yeah, and I want to be clear too, I think this passed in 2015, which preceded my time at the tax department. But the first few years of doing the annual ag cert, there were several folks who legitimately were withdrawn from the program or were no longer farming. And so it definitely does accomplish its intended purpose. It helps sort of formalize, okay, we're double checking and you're certifying to this. But this was trying to get at if come summertime, when we are really at the point we have to withdraw people, because this is currently an eligibility requirement. Right now, their only option is to formally appeal that to the commissioner, and it's pretty time consuming for them, for the local officials, because they have to value the changed land, and it's pretty stressful for the taxpayers.
Sirotkin, and then Senator Hardy, and then Senator Bray. Okay, Senator Sirotkin.
So actually, I remember Doug Farnham was the head of the committee, your predecessor, and supported this change at that time. And I think, as you say, it worked. I don't have any problems with what you're proposing to do. I don't know that the language assures that that's going to happen with a future commissioner. Maybe we could talk about an amendment that guarantees that those things are still going to go out, but it can only be waived after after a period of time they're not received, as a double check. Because I don't read it, I'm having trouble pulling it up, but I didn't read it the first time as being that narrow a waiver criteria.
Madam Chair, may I?
Hardy, yeah, and I've got
Okay.
Senator Bray. I'm trying to read it.
Well, just to be clear, because I didn't understand this until after the commissioner in this is the commissioner of taxes. Okay, because we have a different commissioner on the screen. And so I was like, wait a second, Commissioner Snyder said he didn't do this. Why is he not doing this? But it's a different commissioner. Okay, that makes sense. I think I agree with Senator Sirotkin that we could make this language a little bit more clear, that it's in specific instances that Jill described. I have another question for Abby on the other draft, which I think is the Senate Ag Committee amendment to this. You have A, B, C, and D are what development is, and then E and F is what development is not. Is that correct? I'm not missing something there. Okay, it's
That's
kind
correct.
of strange.
So it's a very large and unwieldy definition. So I was trying to break it up into the different, into making it into a clearer definition.
Okay.
That's why those are in different subdivisions now.
Okay, I just wanted to make sure I wasn't missing a double negative or whatever, but so, okay, got it. Thank you.
Senator Bray, and then Senator McDonald.
So I don't remember the numbers, but my rough recollection is that being in use value reduces a tax roughly 90%, 80 to 90%. So it's a significant enough benefit that it would seem like individuals should be highly motivated to return a pre-filled form and with a signature. I'm all for making it easier to cure an oversight, but I would still want to have something as rigorous and as regular as the certification process, because I think current use, we reimburse municipalities something on the order of $65 million, right? It's expensive, a good program, but expensive. And If you're going to get a benefit that meaningful, I think it's reasonable to ask people to speak up. The other questions for Abby, Ms. Shepherd, these development definitions, do they cross over into, do they line up with Act 250's definitions of development? I just want to,
Might be able to answer that, Madam Chair.
I wanted to make sure
Yes,
we're
I-
not sort of going in, backing into Act 250 yet again.
Donald thinks he can answer that.
I might be able to. About 5 years ago, there were some big, large solar proposals scheduled. And the question was, if a farmer was running into some difficulty and wanted to put in 5 acres or 10 acres of solar to get by, should we permit that? And how would it be dealt with in current use? And the needle, Madam Chair, for a better expression, was threaded by saying that if the farmland is in current use, it shall remain in current use for the lifetime of the solar project. And at the end of the project's lifetime, it will still be in current use, and the owners will not be able to claim, well, it's already been developed, therefore
Right.
it's a development property. And the rationale was that the posts could be pulled out of the ground, the economics might change, and the land would not have been lost as prime agricultural land. And I remember that proposal was put to the chair of Senate Agriculture, and Senator Starr took it home over the weekend and came back and said he couldn't find anything wrong with it. And that was how the needle was thread. And that is how current use land is still under solar panels. And the land is not redesignated farmland, and there's no requirement that additional land be purchased to mitigate the use of that land. And that's a
Okay,
long story, but
Senator,
that's
if
the history.
that's
So-
true, then why do we have to have a statute change now that says that it doesn't count against current use if you put in a solar panel on 1/10 of an acre?
Well,
If you
because
can
we've
put
got
in
it,
a field full of solar panels and it doesn't, that land is still considered in current use.
I think that the Commissioner Snyder talked about odd pieces of open land in forestry, which are not prime agricultural land, for which you never would have had to acquire mitigated land if you wanted to put a panel there. So it's Commissioner Snyder's recommendation to us is, I would say, consistent with the way the needle was threaded for agricultural land.
Is this just for forest land, Abby? I thought it was for both.
It is for
For
both.
both. So is the law that if you, all that huge solar array across the street from my house, if that was in current use as agricultural land, it would still be in current use? And I am paying 90% of the taxes on that land?
My understanding is that if that is that it would not be in current use when those are put on that property. That's why this very small carve out is being put into statute. So if it's on less than 1/10 of an acre in total, it will remain in current use, but anything exceeding that acreage would be taken out.
Okay,
For
but the
forest-
question was, are we getting
both
into,
types.
Yeah,
are we getting into trouble with the definitions of development? Are they
So
the
that,
same or with Act 250?
so this is purely within current use, and I am not familiar enough with the Act 250 definitions to give you a, comparison. I could look at that and compare them, but this really only impacts current use. This is not impacting Act 250 in any way.
Okay, can you check on Senator McDonald's recollection and just make sure what the current law is. Because, yeah, why would you exempt a tenth of an acre if you could do 10 acres?
Madam Chair, if I could,
Yes, Commissioner.
thanks. Just to be real clear here, on the forest land side and the conservation land side, the two aspects that we have that are in our purview, solar installations are not eligible. That's development. It's not eligible. This is creating a pathway to eligibility in a very limited, small and focused on a particular land use area within an enrollment. That's it. That's the new terrain. Otherwise, they're not there. They're not allowed. It's in conflict with the forest use. And so clearly ineligible. That's the status quo. And this is creating a modest little opening on the forest land side to allow that to happen in a small area, that's 1/10 of an acre, and only in a certain part of the enrollment, open land, which itself is very limited in how much can be enrolled. I hope that's helpful, just as a status.
Yeah, I think that is Senator Bray.
Yep. So I'll have to check. I'm just saying this to Senator Pearson, I think, really, but I'll have to check in with Senator Starr. Whenever the Ag Committee does anything in that gets into Act 250 or forestry is entirely in natural resources and energy. So because the House does forestry now, a fair amount of forestry work gets sent to Senate Ag, but I think I would ask to make sure that when there's a forestry piece, this is a very modest thing. But we don't necessarily have things referred on to us. And then sometimes we find ourselves a little bit wrapped around the axle. So.
Okay. I
Well-
don't intend to vote on this today because we've got too many questions. So Senator Bray, if you want to take a look at it.
No, I just trying to.
I would just say this came from an S bill that we added to H88, but the S bill was in our committee. So you may want to talk to Secretary Bloomer about that. I'm guessing, it deals with ag land and forestry land. And so,
Right.
but I hear you. I mean, if we thought this was going to cause a stir or be a significant change, I think we would have probably treated it differently. This seems pretty darn modest to my
Yes.
eye and actually promotes something I think we all want to promote, but maybe I'm wrong.
No, and look, it would have been a chance for a joint meeting, which is, more togetherness.
Perhaps why we forgot to tell you.
Okay. Senator McDonald.
I mentioned before that I opined that Commissioner Snyder's proposal was in concert with the previous ag land stuff. It is not. He recommends we add to statute to not put forest land in the difficult position of being declared now hosting an industrial use, because that would begin to get into the Act 250 stuff. And so to the extent that he is here recommending what he's recommending, I think it's consistent with how we tried to keep this away from Act 250 and give it the same sort of consideration that was given to agricultural land, which Senator Bray has been asked to go out and double check on. So thank you.
Okay. Is there any further issues that anyone would like researched before Tuesday? So the question is, are solar arrays already allowed in current use? I kind of doubt it. And then for those that want to tighten up the language for allowing the commissioner to say, yeah, you didn't send in your postcard, but there's 100 head of cattle out there. You're probably still in agriculture, and I don't have to throw you off and then let you back in, which causes stress. And from what I've heard, farmers have enough stress these days. They don't need a whole lot more. Senator Sirotkin.
When I was agreeing with Ms. Remick that what their intent was and what they planned to do, and I suggested that the language be tightened up, I saw her nodding in affirmation, and I was wondering if I could work with her on some language that might work.
That's up to her. Or you can work with ours.
Okay.
Yeah, no, I think that, that I think Senator Hardy wanted to see it tightened up too. So perhaps all of you can work together and come up with something you feel is appropriately fenced in. Senator Pearson.
Couldn't we just explicitly tie it to the November 1st? Like, in the event the deadline is missed, the commissioner may, I mean, that's kind of what you're saying, isn't it, Senator Sorokin? But we want it only about this the missed deadline, not some of the other criteria.
I think we agree what we want to do. I'm not sure how exactly you write the language at this point. So.
Okay. We don't want it to be a blanket exemption for somebody. We want there to be triggers and, okay. Jill, do you have something to?
Yeah, I know you folks are tired and have a lot going on. I just wanted to clear up a couple things that might save you some concern. So in no particular order, yeah, larger solar arrays are considered development unless it's used explicitly to generate power for the operations of the farming. That's what, and that is why this little piece. And I also wanted to clarify that that is the case in a lot of places where they might have a relatively small solar array or large solar array that helps power farm equipment or processing equipment, and that's already exempt. So this is really, so if I had my, my farm field next to my house and I wanted to plunk down a solar panel to power my house in some way, or my electric car or whatever, that's what, because right now the only way they have to do it is they carve it out and the assessor has to value that little, tiny chunk of property as a separate parcel and charge land use change tax and so on. So this is very rarely does this particular instance that we're talking about happen, because it's usually either a larger array that's generating a decent amount of power or income, in which case it is development, or it's being used for powering the farm. So this is really not a common thing, but it for those very few people that it would impact, it would be appreciated, and it saves some administrative burden as well. And the 90% piece that Senator Bray cited is true in some communities, but the savings on the tax bill really depends on the value of the land in that particular community as it is. So for some places, it's not that large. I definitely agree that it is 65 million because it's $48 million in foregone ed fund revenue. And then the general fund actually pays back the municipalities another 17 million for lost municipal revenue. So you did have that figure correct for sure. And I'm happy to work on the language. I know Abby spent a lot of time on the language to reply to Senator Hardy and Senator Sirotkin, because we were trying to figure out, does this fall under the definition of what ag land is? And then also open idle, does it fall under development? I think it's in the right place. And I know it does read as a not, but I don't know if there's a way around that piece. And this certainly makes it really clear for us and for the local assessing officials to categorize. We really like this cleanup of development because a huge amount of the decision-making around current use enrollment is about the term of development. And you can see, if you look at the statutory language, how it's evolved over the years. So I think this is a good cleanup, and we're very supportive of Abby's edits there. I think that was everything. And I'm happy to continue to help get at what we're trying to get at here.
Okay, Senator Hardy.
Thank you, Madam Chair. Jill, I just want to be clear. The language with the development, the not and the yes, I was fine with that. I was just asking Abby for clarification. I think that the language that Senator Sirotkin, and I don't want to speak for him, but that I was agreeing with him on was the other language about the eligibility requirement waiver and tightening that up a little bit so it was clear. And I think Senator Pearson's idea of just tying it to the deadline may be sufficient to do that. but I'm fine with the other language. Yeah.
Okay. Senator Bray.
So in terms of questions, if Ms. Shepherd could just check in with Ms. Chakowski, I think probably on the development definitions here, and if they in any way trigger things in Act 250, Title 10. So I know we're in different titles, but I don't know how they flow back and forth. Thank you.
Okay.
And if I could just add real quick, there is actually a court decision that articulates that development in current use and Act 250 are not the same thing. That's helpful for Abby. We might be able to find that for you.
That help you, Senator Bray? They are not the same.
It does. On my never-ending quest to understand these two things, if someone could point me in the right direction, then I'll maybe I might
This is
retain
a
it for a
tenth of
while.
an acre. This is not going to trigger Act 250. This is a
I get
tenth
that.
of
I'm
an
just,
acre.
thank you. I'm not really worrying about this much. I just
Okay.
would like to understand the rules of the road.
Okay, so I'm gonna have you do that on your time. Because we don't do much in Act 250. Committee. All right, we're gonna move on from this one.
Madam Chair, there was one more section I actually didn't. walk you
Okay,
through.
I'm sorry.
Just wanted to, it's also very
And-
quick. I will
Is
share
it passed by House or as ag?
from the Senate Agriculture Committee
Okay.
amendment, because it was also in that S61 bill. So it was, everything that was in that bill was amended, put on H88. So I'm gonna just pull up my screen again. Okay, so this is again in the agriculture amendment. This is section 3. This also removes a requirement that the current use board approve the application form for current use. Currently, when the Division of Property Valuation Review creates its application forms, it has to get them approved by the board. This removes that requirement. And then the other strikeouts here are to make the language gender neutral and to just do some more technical cleanup there.
Farmer, okay.
And then
Okay, and is that the board? I am remembering discussions a couple years ago about the board. They didn't meet often, or this is just saying at this point, we're going to trust the tax department to develop the application form?
That's correct. And Jill, you can maybe confirm, I believe they meet annually. Is that correct, to set the rates for the current use program?
Right. We meet in December and January to set the rates and go through the pretty complex calculations that the Agency of Agriculture and Commissioner Snyder's team come up with based on, stumpage rates and milk prices and all those things to set the rates. But this is really trying to get at so that, like, for example, right now we have some updates to make to the layout of the form that we don't have to call the current use advisory board back together to review it. Obviously, we'll still be showing them the form on an annual basis. It's not the end of the world if folks don't feel comfortable with this, but the board was fine with this. And that way we don't have to call them together for a special meeting to approve a date or layout change.
Okay. So the board has seen this proposal? All right.
For what it's worth, I am an ex officio by dint of title, a member of the board, and I confirm we did and we do. And
Okay. They don't want to get called in October, huh? All right. Okay, I think that's it. We will vote on this on Tuesday. For those who need to, those who need to get some amendment together for Titan language, have it ready by Tuesday, and we will vote this one out. I'm getting back to my agenda. Been a week of long agendas. Okay. So the next one is miscellaneous tax. All right. We are we've got two more on there. All right, so Abby is here. You have sent us, or you can put up the final version of miscellaneous tax, our magnum opus. All right.
Madam Chair, would you like me to pull up I've done a side by side and then I have the language, which
Oh.
would be more useful for the committee.
I find side by sides useful. I don't know if the committee wants to see all the language, but I find side by sides useful. So let's start with that. And if anyone wants to, we've spent a lot of time on a lot of these, so let's get through the ones we can with the side by side.
Great. Okay, I will share that. Just give me a moment. Okay, so can everyone see the side by side on your screen now?
Yes.
Great. So the first few sections, there were no changes. So we have the meals and rooms tax amendments for the meal delivery apps and to treat alcoholic beverages the same as food or non-alcoholic beverages when they're being treated as exempt from tax. There's the property tax credit claim form allowing individuals to amend their forms for house site value, house site education tax, municipal tax ownership percentage. There are 4 or 5 sections dealing with payment methods and updating statute, allowing the commissioner to accept all payment types, including check or ACH. There is the current use inadvertent repeal, so that language is being added back in, and the fee for the lien subordination is being repealed. Those are sections 9 and 10. Where the committee has made changes, where your amendment begins is in section 11. It doesn't actually remove the language that was in the as passed House version. It just adds the statutory purpose for the exemption for feminine hygiene products. And then it adds it. So it's pulling in all of the language that was passed out of the Senate in S53. The House did also approve the 2 exemption provisions and send it back to the Senate in S53 as proposed amendment. The next section, the next few sections, nothing is being changed in the committee amendment. So section 12 is the town clerk recording fees. Sections 13 and 14 extend the healthcare related sunsets. So it's the home health agency assessment and an allocation of the healthcare claims tax revenues. Those are both being extended for an additional 2 years. There's a change in the reporting dates in section 15 for drug manufacturers so that their payment and reporting date is aligned. It would all be April 1st. That was a request by the Attorney General's office. And then the workers' comp rate is kept flat at the current rate. And the next, so most of what the committee's proposed amendment does starts actually at the end of the bill. So it strikes all of the effective dates and adds in the yields. So what you see here is different. I think the draft you saw yesterday didn't have these yields in it. So these are
Okay. Yeah, that's what I wanted to check because we changed the property tax rate further down. So that would impact the yield. So as long as we've caught that here, it's okay.
Yes, so these were provided by JFO. I believe I saw Brianna jumping on to answer any questions about that.
Yeah.
Would you like me to stop screen sharing or should I go through this section?
No, let's go through and then we can have JFO talk to us about this.
Okay. Great. So the next, let's see, 3 sections are also from H152. It creates an additional exclusion from the excess spending penalty calculation for capital project costs when they've been granted preliminary approval. It creates this hold harmless provision when determining a school district's weighted membership. And it allows a school district that received a small school support grant in fiscal year 20 to continue to receive that grant. These were all provisions that were in H 152 as passed by the House.
Okay, I thought those were House.
That's correct.
All right.
The next two sections are the proposals by Senator Hardy to require certain data reports regarding property taxes and properties in Vermont. They will both be due January 15th of next year. The first is for the Commissioner of Taxes to propose ways to help towns when they're appraising high value, unique commercial properties, including utilities. It requires consultation with the Vermont League of Cities and Towns. And that, like I said, the report is due back January 15th. There's a second report also from the Department of Taxes on options for collecting and reporting data each year on the number and the grand list value of secondary residences located within the state. That would be prepared in consultation with the League and the Municipal Clerks and Treasurers Association. In that language, there's a requirement that a definition be proposed for secondary residences, because currently there isn't one that's not split out on the grand list. There, it's either homestead or non-homestead properties, and then there are different categories within non-homestead, but there isn't a clear-cut category for what a secondary residence is. So that's asking for more data and some ideas from the department on breaking that out. The next few sections are a lot of the bulk of the discussion yesterday was about the income tax link up to federal statute. Section 23 updates the conformity date for Vermont income tax to March 31st, 2021. So as it noted in the section by section, that would pull in the American Rescue Plan, the ARPA changes to EITC and to the earned income tax credit and to the child care independent tax credit. What is important to note here, it doesn't show in this section of statute, it's being done in the effective dates, but it only applies that link up to tax year 21 and going forward. So this does not impact the way that the legislature chose to link up to the treatment of the first $10,200 of unemployment insurance. This doesn't impact that at all, just to be clear, because that was a tax year 20 change. The estate tax conformity section in 24 is just a rewrite. There was a clause that was a little confusing, so it's just been moved down to its own separate sentence. And then again, a lot of the discussion in your committee has been around the forgiven PPP loan tax treatment. Section 25 repeals what was passed in Act 9, so H315, which required forgiven PPP loans to be included in Vermont taxable income. So this repeals that provision. I have language that Becky Wasserman has worked with the auditor's office to prepare. I've left it highlighted here, and the language also has it highlighted on the website. So it amends the audit schedule for the waterfront TIF and sets out this schedule not less than 5 years for an audit after the effective date of the rules within that section, not more than 3 years from the date the debt is incurred, and then a final audit at the end of the retention period. The effective dates include all of the effective dates from H436 as passed the House, and then also includes for the small school support grants that takes effect on passage. The default effective date is July 1st of this year. And then it has the very important effective dates for the different link ups because they apply it to specific tax years. And the way that the forgiven PPP loan effective date is drafted, the repeal will take effect January 1st, which was when the inclusion of forgiven PP loans and income took effect. So this cancels that out and supersedes it. I will stop sharing now.
Committee. Senator Sorokin.
We just go back to the TIF, the Burlington TIF thing. And could you translate what that means in terms of when these reviews are going to take place?
I unfortunately have not worked on that section, so I will have to defer to my colleague. Becky Wasserman, to explain that in more detail.
Okay.
And,
Maybe we can see if Becky could join us. Will do.
And
Okay.
on the PPP, we don't have to do anything affirmative. We just have to repeal that section and then it gets swept in with every other change that took place.
That's correct.
Affirmatively cut it out, so we're doing away with our cut.
Right.
Yes.
And then on the other ones that are supposed to be for 1 year, what happens next year if the feds continue those credits? Do we have to pass another law to continue them here?
That's correct. So this link up language only pulls in federal statute in effect as of March 31st. So if there was an extension of the EITC or other childcare credit, if that were passed after March 31st, then Vermont would need to take action to link up to that.
What if it was passed?
Hold on.
What if it was passed before March 31st, but extended the program?
Well, I think if we link up next year, because when we link up to the federal tax changes, if EITC extension is in that, then we're linking up to it.
Right. I
Can you
just
make
what we-
the-
I just want assurances that we get a chance to make an affirmative statement on moving it forward as opposed to the default being that it automatically goes forward. And I hear Abby saying that that is the case, but I also just nuanced her to say, if it passes, I mean, isn't it possible that it could pass earlier than its effective date? And is the language tight enough to take care of that?
So are you concerned about another retroactive change at the federal
Yeah.
level?
Yeah.
Yes. So no, because we're only taking, Vermont has the effective date has that separate provision where it applies what's in effect in federal statute March 31st. It only applies to tax year 21. So anything that's passed after March 31st won't be pulled in and applied to tax year 21 unless Vermont links up. So if there's a bill that's passed, even if it at the federal level, even if it applies to tax year 21 at the federal level, Vermont isn't pulling it in unless we say it happens July 1st, Vermont would have to say, okay, we're linking up to the federal code in effect July 1st.
Okay, and I guess what I'm asking, what if it passes on January 1st and is effective, continues the program from March 31st onward? Is it written in a way that we've automatically swept it in because it was enacted earlier than March 31st?
No, so what is, even if it's applied retroactively federally, it's not in, they can't put it in statute previous to March 31st. It's what has been enacted up till March 31st of 2021.
So they would enact it. They may put a start date of February. They enact it in July. It's the enactment date.
I'm worried about the opposite situation where it's enacted in January to be effective. The effective date is
Earlier.
March 31st. And I guess
Of
it's
which year?
The same year. I guess it has it depends on how you define enacted. Is it the date of passage or the day it goes into effect? So it sounds like you're saying if it was passed on January 1st, our law says that it was enacted prior to March 31st. So that new program would continue to be linked up without us taking further action. Maybe I'm.
You're confusing me, Senator.
Okay.
So it's the statutory link up is what was in effect in federal law as of March 31st, 2021. So that pulls in ARPA. If there's a July 1st, 2021 federal action, that will not be pulled in without further action by Vermont.
I'm obviously.
End of all of this is we are going to have to know what we're linking up with. So
Right,
we
so-
changed the whole link up. I'm going to have to cut this short because we've got Becky Wasserman and she's on a 10-minute break.
Done.
And so we're going to go back to the Burlington TIF. And Becky, if you're there you are.
Hi.
Hi, can you interpret for us what this amendment does?
And I apologize. I just another
No,
committee
it's
just took
that time
a
of year.
break, so I hopping over here in Zoom land. So Becky Wasserman, Legislative Counsel. So the language that was proposed by the auditor is amending the TIF statutory section with respect to the performance audits that are required under law for TIF districts. The current, so the waterfront district in Burlington has 3 parcels that have had their time period for incurring debt extended by the legislature. So what this language is doing is saying that for that specific district, it is part of the TIF districts that were created prior to the time when the laws were more uniform about TIF districts. So there's some TIF districts that just kind of were created by the legislature and have, had sort of special rules applied to them over time. So this is one of those TIF districts. So it falls under the category in statute of a municipality with a district created prior to January 1st, 2006. And statute says that those audits have to be done in a particular way, but because this district has had some other changes granted by the legislature over time, this language is notwithstanding how those audits are being performed for those pre-2006 TIF districts, and saying in particular for this waterfront district, the first audit shall be conducted not less than 5 years after the effective date of the rules. That rule was adopted in 2015. So that's basically saying, after 2020, that waterfront district has to be audited. And then an audit shall also be conducted specifically for those 3 properties that were granted an extension of their debt incurrence period last year, to not more than 3 years from the date the debt is incurred. That's allowed by that extension from last year, which is June 30th, 2022. And then a final audit shall be conducted at the end of the retention period for that district, which is in 2035. So it's trying to address a situation where different parcels in that district have different debt incurrence periods, because otherwise I think, as the auditor laid out in a chart, there would be a significant period of time where that particular district would not have received an audit at all.
Senator Sorokin.
I guess that was helpful, but I guess I just would like to understand the dates we're looking at for the audits at this point, where they would fall and how many, because I think that's where the committee was sort of struggling with.
The other one in here is their other TIF, which is due to be audited about now. They do not want to have, they being the city of Burlington, really feels it's unreasonable to have to go through 2 audits because it takes significant amount of time and money to do one, that they would like a break of a couple of years in there. Is this going to give that to them?
So the language in statute says that an audit shall be conducted when approximately 3/4 of the period for retention of education increment has lapsed, and at the end of that same period, where there's 1/4 period of retention. So I'm just basing this on what the auditor's chart is for the downtown district, which is the other district. So it sounds like the current schedule anticipates that for that downtown district, that it would be 2021, but the auditor is proposing it to be 2022.
Okay, I think the auditor's office and Burlington, I've been told, is in the waiting room. So if we can get them in, I think maybe they can tell us if this meets their needs or not. Would that work? Senator?
Yes, I think to answer your question though, it does add an additional audit for those 3 properties in
Yes, I did.
2025. So to the extent that to address that concern, it is not having everything done at the same time. It is adding an additional audit in there in the 2025 year versus
Senator Brock has
now.
had to leave or is about to leave, and I'm trying to get this voted.
So, Madam Chair,
Yes,
we all got a memo from the auditor, and there's one chart in Table 4 which sort of answers my questions, I think. I don't know if Becky's seen it, but it looks like there's some give to Burlington here, but it looks like it's maybe more reasonable than what was originally proposed by the auditor. I don't know whether reasonable is the right word, but it's less aggressive than that's probably not the right word either. It's less than the schedule he had originally proposed, but I don't know if people can pull that up, but.
okay, well, what I'm going to try, Senator Brock has to leave at 3. His picture is still here. I would really like to vote this out.
Okay,
If this is okay, if this is still, we can fine tune this in conference. This is going to be a long conference committee. So, we need to get this bill out if it's going to get done before we go home. And if we're agreed with what we're doing, this kind of wordsmithing can get done in conference. We're trying to find a more reasonable schedule. And we think we've done it. If it's not quite reasonable enough, I would say we can retune it. But other than that, I'm going to have to hold this over until Tuesday, or we might have to meet on Monday. So what's your pleasure, committee? Because we've got 2 more bills ahead of us. Senator Bray.
Well, I guess that there are, if other people need more information, they need more information. For myself, I'm feeling pretty much ready to vote. So.
Okay. Committee, Senator Sirotkin, can you vote? And then if any fine tuning is necessary, bring it to us.
if that's the way the majority of the committee feels, that's fine.
Senator Hardy.
Thanks. I leave the fine tuning of this section to whomever. But I did have, I just wondered if we could hear from Mark or Brianna about the education fund outlook based on our changes. I was trying to find an updated version.
Okay.
Don't know if you guys have
Senator
it.
Brock, what's your time frame like?
It's imminent, but I will be in the car and I will be able to follow and I will be able to respond.
Can you vote? I have to see you.
Yes, you can see me. It won't be pretty, but you can see me.
That's all right. I did a whole meeting while walking and sitting in my car this afternoon. There you are. Okay. All right. So Mark, Brianna, I'm not sure I guess the changes we did to keeping the tax rate level. What's that done?
So the yields and the non-homestead tax rate that Abby has included in the bill now would set the tax rates at the same level they were in FY '21. That means that you will have a reserve of about $15.8 million going into FY '23. I'm not sure what else I can answer for you right now, but it's the yields that are in there in the bill right now reflect what you asked us to take a look at yesterday.
If I can just chime in, the fiscal note posted on the committee's webpage has the education fund outlook if needed.
Yeah, and I also just forwarded a copy of it to Faith. So
Yeah, it's up there now. It wasn't there when I looked before, but thank you, Mark, and thank you, Faith.
Okay, so committee. What is your pleasure at this point? Mr. Hassler?
Yes, I'm sorry to foist myself on the committee. I know you're busy, but I just want to point out that when we left here yesterday, we were wrestling with extra audits for the city of Burlington to be paid for by TIF, which is essentially by the taxpayers from the TIF fund, in excess of what the legislature had originally passed and which we were relying on. And now we come back today. So the idea was yesterday we were going to have an extra one in the waterfront, and we were trying to wrestle with whether or not it would be an extra burden or whether we could time it so that it wouldn't bump up with three audits in 5 years. We now are getting we're getting 2 additional audits added to what was the legislative mandate of 1 for the waterfront district. It's now up to 3. And the timelines would be that the state auditors made it very clear that he wants to commence as soon as possible an audit of the waterfront TIF district. He would now.
Okay, I'm going to tell you what I'm going to do. I would like you and the auditor's office to agree, or this was going to get stricken from this bill. We can't sit here. This came to us. First time we had testimony was yesterday. I thought you were getting 1 new audit and then on the waterfront. And then we were going to move up the one on downtown, so you didn't have 2 back to back. And then there would be another one on the same schedule as every other TIF in the state. Now, I think the committee is willing to help you find some space between the audits, but I don't know that we're willing to let you get away with fewer audits than everybody else that was formed after the statewide requirements for TIFs were put in. And I'm looking for, I don't even have my, Abby, you don't do TIFs, right? Or Becky does. Becky, are they picking up anything extra on this? Are we treating Burlington any differently than we do other TIFs in the frequency of audits?
The answer is no, Madam Chair.
Yeah, I think the auditor would be able to answer that. I think
no.
Better than I can. I don't.
Okay.
I think the answer to the waterfront district is that it has not received an audit.
Yes, we changed the law and it has not had one in over 10 years. Right. And it now could go another 10 years.
Madam Chair, I sense your frustration with what is perceived to be a smallish issue, and you have a lot of work to do. Let me just say one thing. You guys gave us the authority and the responsibility to do this work 6 or 7 years ago. At first, I wondered, is this the best use of our resources? I now believe it is, and that we are the only entity in state government that can do it independently and appropriately. As part of that responsibility, we occasionally will come to you and your colleagues and say, look what we found. In this case, we found a process issue. I'm asking you and your colleagues to trust our professional judgment rather than the self-interest of a TIF town. That's really all that's going on.
Okay. Committee, as I said, we can continue to take, testimony as a committee of conference, or leave it to the folks that represent Burlington to work with them. Senator Pearson.
Am I right, Madam Chair? And maybe for you or for Becky, we need to put this in there to kind of, if nothing else, as a placeholder, right? So that,
Yes.
So is that seems to make sense to me. And if the auditor in Burlington can get more peaceful about the schedule, so much the better. But
It
if we
can be
don't put
audited.
this in,
It can be audited. It can be changed.
Okay.
Okay. All right. Senator Bray.
So, my preference would be for our default, for whatever we move, to be moving what the auditor's proposing. And if there's a liberalization or whatever it's called, it happened in conference.
That's what we've got that Becky has given us. That's what we have. And if, we can work out something that works better, we can change it in conference. It just has to be in either bill. And it's not in the House bill. So we've got to get it into this one. Senator Sirotkin.
So I'm fine with voting the bill out. I'm not fine with the presumption that this is the default position. This is my largest town by far. And if we're not fully educated on this, I'm happy to advance it to keep it going. But I think that the conferee should be viewing this with an open mind. And if there's no agreement between these two parties, I wouldn't just want it to be the default position because we're forced to vote on it today.
No, I think, the other body hasn't heard this at all.
Right.
So the best way, we're going to have to make a decision. If this were normal times, I'd send the two parties to the hall and tell them to work something out. Because we have to make a decision and they're going to be much happier with what they work out. It's harder to do here, but we've got to have something in here as a placeholder. It can be changed at any point, but in the committee of conference, but it's in there. All right, Abby. We've been through it all, right? Okay. Any other questions or discussion by the committee? If not, I'm ready for a motion if Senator Brock is still with us.
Madam.
I am
Yes.
still,
Okay, Senator Brock's still here. He's in cell phone range.
Okay, and I hate to do this, but just because I've been bouncing in and out.
Yeah.
So we've got the House bill. We've added the menstrual tax. We've added this TIF language. What else have we done?
What else have we done? Don't ask. We have
Oh,
kept
we
the
added
tax
yield.
rate. We've changed the yield. We've
At a
kept the
flat
tax rate there.
We
Abby,
added,
you've got the side by side. Why don't you flip that back up?
There are also the two reports that Senator
That's right.
Hardy
Senator
proposed.
Hardy's two reports from the tax department.
There's
We've-
also, oh, sorry, Madam Chair, I can't see.
Okay, no, we have done the EITC for this year. We have done the dependent tax credit. We have done the PPP forgiveness or non-taxable. Let's see.
Thank you. So did we put in the EITC, that whole suite?
Yes, it's all
right.
in.
Yes, that's section 23.
Thank you. See, you're reminding me all the things I was concerned about. Appreciate it.
Only for this year. Okay. So committee, are we ready for a motion? And Senator Bray, I'd like to Bray, Brock, I'm not sure what your thing, you're here, okay. Senator Bray,
Here.
I don't know when I'm gonna lose Senator Brock out of cell phone range, so go.
I move that we amend H 437, I have my number right still, as in, I don't have the time and date stamp.
Would you like me to give you the draft number, Senator? Would that be helpful?
Yes, please. I can't see it. I can see the side by side, but not the.
It's H 436 and it's draft 1.4.
Thank you, ma'am. So I move that we amend H 436 as laid out in draft 1.4.
Okay, further discussion? If not, I'm going to ask now we can do this. All those in favor say aye.
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 Opposed say no. I am hearing 1, 2, 3, 4, 5, 6, 7, 0, 0. I'm going to hold with tradition. I'm going to report this unless some of you would like to let me know that you'd like to report a section of it. Senator Bray. Oh, then we have to approve as amended.
Yes, I wanted
All right.
to move that we vote out favorably H 436 as so amended.
Okay, further discussion? If not, all those in favor say aye.
Aye.
Oh, say no. I'm hearing that as 700. Thank you, everyone. Senator Brock, enjoy wherever you're going. We've got a couple other things on the agenda, and I've got to go find them again. We did
Well, I'll stay
miscellaneous.
connected as long as I can stay connected.
Okay. These probably aren't, we have H 437. Did we get that last number right? It was 437 was miscellaneous changes and changes that affect the revenue. That's 437. 436 is miscellaneous. Okay, as long as that motion was correct. So 437, that's the surcharge on $1 million homes and $1 million businesses. It is, and let's see, the surcharge, the mobile home tax credit, and the manufacturing machinery and equipment tax. And I understand that the House is very serious if we are going to spend basically ed fund revenue, they are going to make it up. Originally, I was told this had to do with the water, clean water bill, but I now understand that the machinery and equipment tax will remove some money from the ed fund. And so they're doing this surcharge. Abby, do you understand what they're doing with that? And
my understanding is they've taken the language as passed by the House that you're considering right now and are amending it into a different bill. But my understanding is that none of the language has changed. So both committees are considering the same proposal.
okay, but isn't there something in this bill that moved money around from different funds?
So this
No.
bill dedicates all of the surcharge revenue to the general fund.
To the general fund, okay. Senator Sirotkin.
Madam Chair, I don't know if you received an email or two from me on this, but Abby raised the same question I was raising. The bill's on the House floor again, these provisions in another bill that is a bill that is an economic development bill. So they're passing it twice. I think it's in slightly different form in the second time. They don't have the manufacturer correct me if I'm wrong, I don't think they have the manufacturer's exemption in the second bill, but they have the property transfer tax surcharge and the mobile home on there. And basically what, I don't want to discuss the communication I had, but I think it would behoove us to take some time to sort this out.
Okay, maybe we should, if they've got bills on the floor with these
In a slightly different
provisions,
Yes.
or at least the manufactured
home.
home. Abby, what's?
Yes, I'm sorry. I
what's
thought you were just referring to the property surcharge. So Senator Strachan's correct there. So H437 has those provisions you listed. So it has the manufactured homes tax credit. It also has a sales and use tax exemption for manufacturing process. It expands that. So those are the two expenses in that bill. And then it also raises revenue through the surcharge. And that's what I was referring to as having the same language. My apologies for misunderstanding the question.
So there is a second House bill that has all of this language in it.
I believe it's an S bill. It's a Senate bill.
It's
Is
a
that correct,
Senate
Graham?
bill.
101, I believe.
Well, where is the,
101.
where is the Senate bill?
It's
It's
on
S-
in the House.
action tomorrow on the House floor.
Right, it's S101. It
We
came
passed all of this and it got presented on the Senate floor?
No, not these provisions. They're trying to tack it on in two places. So they're putting it onto this bylaw modernization bill that came out of my committee. So
Well,
they're playing the end game.
all right, so maybe we just sit on this bill and see what they do with theirs. And if they send it, oh, well, yeah, if it comes back, there's no guarantee it'll get passed. All right. All right, all right. I told them I told Ways and Means that I didn't think we had any problem with these. I know they're important to them, but all right. Then we can go on to the most fun part. And this one we're not going to get out of here today either, because there's a
Madam
whole
Chair.
lot of people that want to talk to us about it.
Madam Chair,
Yes.
but before we shift on, I wonder, and I see Pearl has a question, but I wonder if some of it, how the hit on the ed fund because of the teachers' benefits, the retired health, whatever, is that one of the dynamics that, where'd you go? That,
I'm still here.
okay.
I'm trying to eat lunch.
Okay. I'm wondering if that's one of the dynamics that is making some of these bills a little more complicated that you're referencing.
Well, I know that Ways and Means is concerned about switching that to the ed fund. But this was discussed at money chairs with leadership. It is kind of a poor stepchild. It's been in the general fund. It is, there's some discussion about perhaps putting it back on school boards, you know, individual districts. So these funds have
I'm
been.
comfortable with the Senate position. I'm just saying that when you say that the House is going to want to fill it back up, I wondered if it's part
No,
of that.
this, I don't think there's, you know, I haven't been told that there's any real issue. And I've told them, I think the things in the revenue bill were haven't gotten a whole lot of controversy so far. Mark, can you help us understand what's going on?
Not on this particular issue. I just wanted to let you know, just really briefly, the education fund outlook that I sent you to look at assumes that 437 and the machinery and equipment tax passes, so it's included in your outlook. It does not affect the tax rates or the yields. It only affects the size of the surplus on the bottom line by $900,000. So I was assuming that that was a done deal. If it's not, that's a $900,000 change in the size of the surplus in the Senate Finance Committee version of the outlook. But again, it does not affect the yields that are in the bill that Abby's included.
Yeah, I don't know what's going on with sticking the revenue bill 437 on a Senate bill. Except somebody's getting antsy about something and it's the end of the session. But if they're going to put it on, we can wait until Tuesday and see how they do. And pass it out, or we can pass it out and have two bills in play. That's definitely not the first time that'll happen. I'll leave that up to the committee. I mean, I'm not sure. Unless, we're Senator Sirotkin.
I would rather wait till you and I can have an offline conversation.
Okay, yeah, we'll get this out. I don't know what's in, no one, the chair of Ways and Means didn't say anything about this to me at noon today. So I don't know where this attaching it to an S bill is coming from. It's the first I've heard of it, and I haven't seen probably your email, Senator, because I just haven't gotten to emails since 9 o'clock this morning. But okay, so we're going to go on to the miscellaneous energy subjects, and we're going to let Abby, can you get me a clean copy of 436? And I think Faith already has let the pro tem know that we voted it out. I will let him know that I'm reporting it. As soon as you get it to me, I'll get it up to him. Okay. Thank you. Okay, so we're looking now for Ellen, and we are not, what time is it? Oh no, it's 3:30. We're not ahead at this point. We'll give Ellen a couple minutes. There she is. Okay. So Ellen, I'm going to Ellen, let's bring that bill up, walk us through it. And then I believe there's some proposals from Natural Resources and Energy to add to this. So let's see where we are. Okay.
And Madam Chair?
Yes.
I'm not sure which ones we're going to be looking at, but we did have a brief discussion about standard offer, and the other day, I don't think we've actually seen language from Ledge Council, but it was my understanding that we were going to, because I think many of us have already received a number of emails about being able to provide testimony. I thought we were going to hold off on the standard offer piece until our next committee meeting.
We're going to take testimony, but I think it would be helpful for us to know what we're going to be taking testimony on.
Oh yeah, absolutely. I just wanted, I was trying to make sure that you weren't aiming for a vote today yet.
No, I'm not aiming for a vote today. I'm going to give time for everybody to be heard.
Okay, and I think we also have some things to get to before then. So, hello, Ellen Tchaikovsky, Office of Legislative Counsel, H431, the Miscellaneous Energy Subjects Bill. Your committee worked on it on Wednesday, I think. Yep, and But before that, this committee hadn't looked at that bill in a while. So there were some amendments from like a month ago. So I have prepared an amendment today. It's draft 1.1 on the website under my name. So
Yep.
I definitely want the committee to look at what I've included to make sure that all of these are amendments that you want. So the last instance of amendment on this draft is the amendment this committee discussed on Wednesday to include the S-128 language. That was draft 1.5 from my colleague Abby Shepherd. So I will get that to that at the end. That is included in here, but the first few instances of amendment do amend the bill as it came over from the House. So first, this first instance of amendment amends section 5, section 201, which is the definition section in Title 30 related to jurisdiction, and the 200 block of the statutes where the PUC regulates. So already in statute, there is this definition for energy storage facility. There was a proposal of amendment to that definition as proposed by Mr. Murray that you heard from related to hydrogen. So that definition is in here now. So energy storage facility would mean a stationary device or system that captures energy produced at one time, stores that energy for a period of time, and delivers or may deliver that energy as electricity to the grid for use at a future time. So then there was this additional sentence that reads, this includes hydrogen storage facilities that may deliver the energy for use at a future time in a form other than electricity. So I don't know a ton about hydrogen. And so I don't fully understand the implications of adding this definition here. I'm not saying that it shouldn't be added here, but this definition is used throughout the sections of Title 30 that refer to energy storage, including the section in section 248 that governs the PUC's jurisdiction and granting of CPGs. So,
do these things exist now?
I don't know. Yeah, I think he had pictures.
I don't know if they exist in Vermont yet. I think they exist, but I don't know if they exist in Vermont yet. So I just want to say that I think it's probably fine to add this language here. I don't fully understand all of the implications that may have, particularly because this bill does amend the threshold for CPGs and how they're issued, and we'll get to that in a minute, but it does use it sets a threshold for energy storage CPGs above 100 kilowatts. And I don't know if hydrogen is converted to kilowatts. So, so there's that.
Madam Chair?
Yes, Senator Bray.
I know many of us have been in and out of committee to go keep track of something in another committee. I don't remember direct testimony in this. I don't know if I missed it.
Yeah, we had Tom Murray in.
Okay, so I missed that. I'll have to go back and check that testimony.
Okay. Again, this can come out in conference and he did have pictures, I believe. We'll ask him to come back in. We'll ask him, we aren't getting this one out today. So we'll ask him to come back in on Monday. Okay,
I mean, I think
We're
part
meeting
of the
Monday.
question, I'm sorry. Part of the question, I think, is once it becomes part of a CPG, what is, what are the consequences of having it become part of a process? I'm just not really sure what we're conferring on it by.
okay.
That's
So if you want to, you can drop Tom a line on Monday and talk to him personally, and
Yep.
we'll see if we can get him back in here on Tuesday.
Thank you.
Okay. So Ellen, why don't you keep walking us through?
Okay, so the second instance of amendment also amends language in section 5 of the bill, which again is the definition section in Title 30. And this amendment, I think, might have been proposed by the Department of Public Service, but I actually also am proposing this amendment because it adds, I think that this phrase is a little bit confusing. So section 6, what's in the underlying bill is energy storage aggregator means an entity other than a distribution utility that is operating an energy storage capacity of 100 kilowatts or greater aggregate nameplate capacity, unless the commission establishes a larger threshold by rule. So I am proposing to strike the last phrase, unless the commission establishes a larger threshold by rule. We're talking about, again, the section 248 language where what the threshold is needed for when you need a CPG. And so the question is, are you setting a statutory threshold of 100 kilowatts or greater, or are you establishing that the commission may propose a larger threshold in the rule? So particularly because this is a definition section, I think having the ambiguity about whether the commission is establishing a larger threshold makes it a little confusing. So that's a recommendation from me. And so the committee can please feel free to take it out of this amendment.
Committee, any thoughts on that? Let's keep going.
Okay.
I think it was to provide some flexibility because this is all so new. But it may be a better place. We may be able to add that flexibility. The commission shall be able to alter. All right, at some point. Okay, let's.
And they'll come to us. Yeah.
So the third instance of amendment is in section 6, section 203 of Title 30, and it's adding a phrase, and this was proposed by the Department of Public Service. So in section 203, the phrase storage is added, and this is in relation to the PUC's jurisdiction. And so this is just adding a statement that says, for purposes of this section, storage has the same meaning as energy storage facility as defined in 201. So just sort of, this is clarifying language, and I'll show you here on page 4. So section 6 adds that a company engaged in the manufacture, distribution, transmission, distribution, storage, or sale of electricity. So this is clarifying because we're not using the defined term here.
Okay.
Okay. So next is the fourth instance of amendment is another proposal from Ledge Council. And so again, if you don't have any interest in this, please stop me. So in section 8, we're amending section 231, and we're adding language about storage aggregators under the certificate of public goods section for 231 CPGs. So it currently reads, for an energy storage facility not already subject to this section, an energy storage aggregator that operates an energy storage facility is subject to this section only if the aggregator is not a retail electric provider. So I'm proposing to add that, to get rid of that first clause for an energy storage facility not already subject to this section. And the reason I'm proposing this is because this section 231 deals with which companies need a certificate of public good. So it refers generally to companies, not to individual facilities, generation facilities, or storage facilities. So I think that that confuses this issue. So I think that if we just take it away, the language is still the same. An energy storage aggregator that operates a storage facility is subject to this only if they're not a retail electric provider.
That sounds clear to me. Senator McDonald?
Which means if they are an electric provider, they're entitled to what?
They have to get a CPG under section 231.
Which is what we intend for them to have to do, right?
Mm-hmm.
Right.
Okay.
Alan,
I'm lost in the double something.
Well, and can someone remind me where the aggregator language in general has come from this year?
I believe, so it was worked on in the House. I believe it was proposed by Renewable Energy Vermont. I didn't originally draft it.
One of those, all right.
Yeah.
Okay, a legacy drafting.
Legacy drafting, all right.
Okay, got it.
And so I think this language was also a part of their proposal. So it is having energy storage operators, energy storage aggregators be subject to section 231 and requiring them to get a CPG under that section. But it's clarifying if they're not a retail electric provider.
Okay. And may I ask a follow-up?
Yes.
Is there, so they go through the CPG process. Does this have any, I just want to make sure I understand, is there any obligation for a utility to accept power from such an aggregator? I mean, for instance, standard offer like, or is it that you have to get a CPG and then it's up to you through a power purchase agreement, for instance, to go get a contract with the distribution utility to take that power?
No, so it doesn't directly confer any obligation that way. I was going to raise that this section 231 may sound familiar because we have recently been discussing it in regards to global foundries.
Right.
So there are section 248 or 248A CPGs, but then 231 CPG just refers to operating a company within Vermont. And then the PUC can set conditions on the operation.
Okay, moving closer. We started out talking about putting a battery next to a solar array. When I think of aggregators, I think of someone that gets a bunch of power that they may or may not own the solar array, and they store it and then they sell it out. Is that, or if I'm a private company, I have a solar array, I store my solar and then I sell it to the utilities when it's cloudy. I mean, are we talking about a new animal, which is someone that builds a bunch of storage capacity and then buys electricity and stores it and resells it? Or are we talking both?
So I'm not sure if they are going to be engaged in selling the electricity or just the service of storing the electricity.
Okay, so they sell the service. I am XYG Solar Array Company. It is July. It is sunny. I'm getting all kinds of stuff. I can build my own storage, or I can lease space. There could be a separate company that could take energy from me, store it. Could they, and also take energy from XYZ Solar Array Company and store it for a multitude of companies that then sell it to the grid under whatever contractual arrangement they have?
I don't know the
Maybe.
answer to that.
Okay, maybe
I'm
it
not
would help if
sure.
we went back to the bill and walked our way
that's what-
through the bill as a whole.
Madam Chair, that's what I was going to ask. It looks like, Ellen, on the screen you have what would be a strike all, but on our website we have just the instances of amendment, and so it's a bit confusing.
That's what I've been looking at.
No,
So
so
if-
I did not do a strike all, just the instances of amendment. What I have on the screen right now is just as the bill came over from the House.
Oh, I see. Okay.
Yeah.
Okay, so I've been reading it off my screen, and maybe what I need to do is go find up there.
But I can go back to the beginning and we could walk through the whole bill.
Let's walk through the
you-
whole bill. I think we're obviously, it's the end of the day on Friday, and we're getting confused. So we're going back to, this is 431 is passed by House. Is that the document we want?
Yes.
Okay.
All right, so section 1 relates to the jurisdiction between OSHA and DPS if there is an accident.
Yep.
And so there is currently no proposal of amendment to this section that I am aware of. But it's clarifying that the OSHA will handle these investigation of these accidents. But the department shall provide support.
Rather than have two separate investigations.
Right.
Okay.
The second section is a Public Records Act exemption, and it's for records relating to a cybersecurity program. And this is in case DPS in their records has information related to a utilities cybersecurity program. So that should be exempt from the Public Records Act.
Yeah, I don't think anyone's objected to that. Okay, then we get to section 3.
Yes.
All right.
Yep, and so this is updating definitions in Title 30. Oh, so actually, this is updating definitions in Act 250.
50.
So, yep, so the construction, the definition of development under Act 250 currently exempts generation or transmissions facilities that have received a Section 248. So this is adding energy storage facilities as being exempt from Act 250 if they have a 248 CPG or are being regulated under 8011, which is a section in this bill that will also regulate energy storage facilities.
Okay.
And
Making sense now.
yeah, so section 4 is doing a very similar thing in Title 24. So again, extending the exemption for regulation by municipal bylaws to energy storage facilities that have a Section 248 CPG or are regulated under 8011. So both of these amendments are seeking to treat energy storage as other types of energy facilities.
Okay.
And no amendments are proposed to either of those sections.
Have have you looked into these enough to know about what they're like to live next to? I mean, I can imagine someone deciding that a great location is right in the middle of a neighborhood where there's a substation. Some things, I've been around a substation that I was told would have a very low level of sound at its fence line. That was how it was permitted. But we lived about a mile away, and on a quiet night, you could hear that substation just humming away. So I'm just trying to make sure we don't, and these things are quite compact. They're big, they're not very big. So I'm just wondering if we're going to be protecting abutters from being exposed to things that they might reasonably think they wouldn't be living with.
So section 248 incorporates by reference all of the Act 250 criteria, including aesthetics. So section 248 is a slightly different process than Act 250. But in theory, the protection is still there.
Okay, thank you.
Okay. Yeah, all right.
All right, section 5, this is where the proposed amendments in my document start. So section 201 in Title 30 has has definitions that are used, including the existing definition of energy storage facility that was added 2 years ago when the PUC first began regulating energy storage via CPG. So this language is being proposed to be amended here as passed by the House, but also in the first instance of amendment, as we just discussed, adding the language about hydrogen storage facilities.
Okay.
And this, so these definitions in 201 are used in multiple places in Title 30, including in Section 248, which is where this will largely come into play.
So we are adding the hydrogen, or the proposal is at the end of Section 4.
Yes.
Or sub 4, okay. And 5, is the proposal to make any changes there?
No. Nope. And so this is the definition of energy storage aggregation, which means a virtual resource formed by combining multiple stationary energy storage devices at different points of interconnection on the distribution system. Madam Chair, I do not know very much about how these work. So you may want to hear from someone else on specifically what it is these businesses sell, because I'm not entirely clear.
Okay.
But this is a new definition that's being added. They haven't been regulated this way
Aggregators
before.
being added, okay.
Madam Chair.
Senator Pearson, yes.
Yeah, I'll risk my ignorance here and just paint the picture for committee of, 24 batteries that are controlled, that are spread out across, say, Burlington, but are controlled centrally from a computer. So it'd be hard to regulate them because each individually they're small and they're outside of regulation. But because my business is pooling that power and feeding the grid as the utility needs, we should have some glimpse at it. I'm sure I'm simplifying and I've probably got it wrong, but I think that's more or less what you can picture, because now, it's so sophisticated to be able to be remotely controlled. But I did have a question for Ellen about, you said you thought we should strike the unless the commission establishes a larger threshold by rule. I agree that it's a clunky sentence, but as I understand it, the initial proposal was 500 kilowatts, and then people wanted it to be lower, and we weren't sure. And so it was part of a compromise to get through the other body. And so I'm wondering if we could just more artfully frame it, but keep the construct. Maybe 100 makes sense. Maybe the PUC would think it should be 500. Maybe it should be 400. I have no clue. But I think there's potentially a significant economic impact here. And so if we just keep it at 100, I'm a little uncomfortable. I actually like empowering the PUC on this one. And so I wonder what others think, or Ellen, if you can confirm that this language was kind of part of a compromise on the other side.
Could we do 100 kilowatts or greater aggregate nameplate capacity, or a rate set by the commissioner?
Not the commissioner, but the commission.
The commission. I mean, the other, we could also put in here somewhere, the commission may at any time change the definition or increase we want to put flexibility in. We don't want to say it's wide open until we find out what it is. But we don't want to have to come back and go through the entire legislative process to say, oh, this is working really well. Maybe we should do 200 kilowatts.
What if we said shall be no less than 100, but subject to a rule or something like that?
Yeah.
Sure, you definitely have that option. I think the difficulty from my perspective is that you're determining the threshold in statute. It determines what the threshold is to get a CPG. And so this is, you could just leave that to be set in rule. You could just set in rule what the threshold is. And this definition 6 is used in 231, which is sort of where we stopped, saying that we're determining which energy storage aggregators need to get a CPG. So a company that's in business will look here to determine if they need to get a CPG, and it says with a storage capacity of 100 kilowatts or greater, unless established by rule. So a different threshold is established by rule. So it's then directing to look to see if the PUC has established by rule a different threshold. And I don't think that this bill anywhere actually directs the PUC to do a rulemaking. And so it could be at any future time. So I just wanted to raise that does create an ambiguity to some extent, because you're directing people to look if the commission has established a rule, but you're not having a requirement here that they actually do. So, but you do have some options if you disagree with my suggestion. You do have some options if you'd like to change it in a different way or leave it. This is the first time that the energy storage aggregators are being regulated. So I think there was perhaps question about whether or not 100 is the amount. 100 kilowatts is what is being proposed for the CPG amount in section 248. So those amounts match.
It doesn't say you can't build anything bigger. It just says to do that, you have to get a CPG.
Right, and this specifically is saying if you are an aggregator who has in aggregation more than 100, you need a 231 CPG to operate.
Is it costly to get that?
I don't know.
Then if the neighbors are happy or not.
I mean, it's not trivial, right? So that's where people actually do care what we do here. All right. Well, I don't know. I don't know which way to go, but I'm a little out of my depth.
Hey, Ellen, I'm sorry, Madam Chair. I'm not sure if
No,
anyone.
that's fine. I can't see you, so you have to holler.
Okay, you may have already answered this. I'm so tired. I'm having a really hard time following everything, but what does nameplate capacity mean?
Amount.
How much it holds.
It's sort of a sticker. It's like
Like, oh, whatever's on the sticker?
It's like your mileage that the dealer tells you the car does.
Okay, so it's
Or
it's
the
only
how
what-
much gas your tank holds.
so it's what it's supposed to it's what its capacity is supposed to be, not what it might actually be.
Oh,
It's sort of what it's filled out.
yes, that was Andrea Cohen's. The output can vary widely.
Right,
This-
okay.
The capacity, it doesn't have to be full all the time, but that's what it could hold when it was full.
Got it. Okay, thank you.
But it'll come and go depending on the sun, the wind, or whatever is feeding it. Or it's being taken out of.
And my recollection was this 100 kilowatt or greater was in part to avoid the sort of wall mount ones that could be in somebody's basement. Like it has to be big enough to not just be a residential one.
Right.
No, that's the storage, not the aggregator.
Oh, okay, sorry.
Right, so aggregators will definitely have multiple of these storage devices. The 100 kilowatts, I do think comes from the recent FERC order related to energy storage. So I am not deeply familiar with that, but there is a recent FERC order, I think it's 2222, that came out addressing energy storage and set a level at 100 kilowatts. And so I do think that's why the agencies were interested in using that as a threshold.
Sounds like as good a reason as any.
Well, and I don't think we're allowed to diverge from a FERC order. Is that correct?
So the FERC order only does specific things. So I think that it doesn't address whether or not something needs a CPG, but I think the FERC, I'm not 100% confident on this, but I think the FERC order is related to that ISO New England may be starting to regulate energy storage larger than 100 kilowatts. And so while that doesn't necessarily relate to our CPG process or interfere with it, it would be potentially beneficial if the same number was floating around. But I am not an expert on this.
Right.
Well, the other thing I wonder is, I mean, this is, I don't know enough either, but then as the amount of stored energy goes up, then I think it becomes eligible to be dispatchable. And then you start having different relationships in terms of how much, what the interconnects will be, and then who's going to dispatch and control it, the market you operate in. I don't know the answers, but I think
Listening to this, that this committee, we need to have some witnesses in here to help us understand this. I think it's 4 o'clock on Friday. We have put out 2 major bills. The word slogging has been used more than once. I think it might be better if we put this on for next week and got the appropriate folks from the department and the commission and let Faith know on Monday. We'll give her a whole weekend off. And we'll see if we can't line some folks up. I'm getting a lot of pressure on the income tax and the cloud tax. And I've said we have set up testimony for, I believe, Tuesday next week, but we will get these on and we may have to move that back. All right. Does that one work? Because
Are you saying, Madam Chair, see you later, aggregator?
pretty much, yeah. That's what I mean. We are devolving into bad puns. And I think we should, I think we've all had it. I think it's time. This is just, it's too far. It's not logical from any of the discussion we've had earlier in the week. So enjoy your weekends. Call everybody. Are you saying goodbye? Are you asking questions?
I have a question.
Okay. All right.
Sorry, Madam Chair. I was just wondering if Ellen, if you could make this a strike all amendment. So when we look at the language, we can look at it in the context of the full bill. That might be helpful for our kind of meager, mushy brain.
We're having trouble visualizing.
Yeah, I've been going back and forth and I can't follow it. And I know it's more efficient to do the individual amendment.
Work better on a night's sleep.
Yeah. And I agree. Somebody from the PUC would be helpful to hear on this.
Sure.
Okay,
before
and we
I
need
add
to
in-
get Tom Murray back in to talk to us a little bit more about hydrogen. And Senator
Good night.
Bray, you had,
Well, for whoever wants to speak about aggregating and why we want to go that direction, it'd be good to hear sort of the electrical or business rationale and sort of hear the case again. I think it'd be good to ground it. Like, why do we want to go this way? I can imagine things, but I don't want to imagine anything on someone else's behalf.
okay.
And can I add something on that quickly? Because I did want to bring this up. So part of the reason they're being added is because there's a little bit of a gray area in section 231 about what specific companies other than utilities are regulated by section 231. And the reason I have become very familiar with this recently is because it's part of the Global Foundries petition. So it is a bit, that section 231 is ambiguous. So this is bringing energy storage aggregators clearly within section 231. So there is some clarification there. But also, there's also this language in section 7 that we haven't spoken about recently that is interesting now that I know more about this, because so it's adding to section 209, which is the PUC's jurisdiction, energy storage facilities. So, and it's adding this language that competitive suppliers of energy storage services that do not serve retail customers shall be exempt from sections 107, 108, and 109. And this is of note because similar to the discussion about Global Foundries, there's this concept in the section 238 CPGs that recognizes that not all companies need to be regulated to the full extent as utilities. And so the Public Utility Commission has this concept of de minimis regulation. And so it does usually regulate non-utility companies under de minimis regulation, which exempts them from 107, 108, and 109. So this is establishing that energy storage aggregators would fall under this concept of de minimis regulation under 231. So that is just of note because it's the first time that is sort of explained in statute, this de minimis regulation under 231.
Okay, so we need to ask the PUC to come in and walk us through who is the origin of this bill.
This bill did, Ann Margolis at DPS has been working on it because it came out of a report from last year on energy storage that the legislature requested. And then
Okay,
there were amendments requested by the PUC as well as Rev.
all right, so we need to get all of those folks in. All right, Senator Pearson.
Thank you, Madam Chair. Am I remembering that there was, Senate Natural was wondering about extending the sunset on standard offer? And I,
That's the part we haven't even gotten to.
okay, I hope we will talk about that. I personally, I think that makes sense just to extend it. I don't want to push my luck, but Senator Perchlik brought us this little tax clarification around wood pellets.
Oh,
Remember that? And it was like,
Yeah.
the tax department was like, yeah, that would clear it up.
but it's
I
not
want-
it's,
I don't know if
it
it's
isn't a
allowed.
bill. I
It
I
was an
don't
S-
remember,
It was an
I don't
S bill
remember
and a-
seeing it on the list of bills, or it would have tweaked my memory. Okay,
I
we'll
just
get-
wonder if we could add it here. It's-
yeah,
I don't want to be greedy, but it seemed like it would be a little energy
Yeah.
tax related thing that.
yeah, no, I think that we should have put that on miscellaneous and I missed it, but
Well, this is the miscellaneous energy, so.
this is miscellaneous. We got more miscellaneous bills this year. Okay,
Okay.
have a good weekend. I think we've all about had it. Faith, you want to stay on and talk to me?
Ending live stream.